So I inherited 3 properties from my father. I live in Texas and the properties are in South Florida. The only catch is I found out all 3 properties have tenants in them. What do I do? I'm Ellen Mitchell, your heels on the ground in the Miami-Fort Lauderdale area. And on this channel, we talk about everything: probate, guardianship, senior relocation, and out-of-state sellers. Today, we're talking about this. I got this call last week from a seller. She's in Texas, and she inherited 3 properties in South Florida from her father. Come to find out, all 3 properties are occupied. It sounds great to have inherited the 3 properties, and it is. But the challenge becomes she was never given any documentation from her father. She doesn't know if these tenants are there on a month-to-month lease, or a month-to-month tenancy, an annual lease, what their names are, their phone numbers, how to contact them, or even what they're paying. She doesn't know if there are security deposits in place. And as I said, she lives in Texas. So I really thought about it and I was like, how can I best guide her? I emailed a couple of real estate attorneys that I know and had suggested perhaps we could have an estoppel ordered. What is an estoppel? An estoppel is a form that's filled out when a property is sold, where you go to the property, someone goes to the property, and they confirm with the tenant their contact information, security deposit, how much they're paying, and the tenant signs that. And so they both thought that would be the best idea if we could go to the property and get the information from the tenants. After thinking about it more, who's going to go to the properties? And so I was able to make an introduction to a property management company that I work with. She's going to turn over the property management of these 3 properties to the property management company, and they will be going out and hopefully, fingers crossed, getting the information for the tenants. It's really tricky because it would have been so much simpler if she had the information ahead of time. Now you're really relying on what these tenants are saying because she has no written documentation. So the property manager will be going out, they'll be getting the information from the occupants of the 3 properties, and they'll be telling them that as long as the tenants are willing to allow the property to be shown, that she's going to keep the tenants in place, she'll keep the rent where it is, and go ahead and sell the properties. But this could have all been avoided by everything being documented and sent to the daughter ahead of time. So Florida law actually says that a lease supersedes a sale. What does that mean? It means that if all 3 tenants have leases in place and she wants to sell the property to somebody who wants to move in, they have to wait until those leases expire in order to move in. It doesn't matter that the person that signed the lease is now deceased. The lease supersedes the death. So for example, if she's got 3 leases that don't expire until February 2025, she cannot have those properties vacant for a new buyer prior to the expiration of the lease. She's not required to renew the lease, but she cannot cancel the lease during the term of the lease. In this situation, if there is no lease and the occupants say that they're month to month, it would be easier for the landlord. She could give them 60 days written notice and they would have to move from the property. But you're relying on the information from the occupant instead of relying on the information from the landlord. Back when the market crashed in 2006 to 2008, we saw a lot of fake leases written in these types of scenarios where the person who did not have a lease would write a lease at sub-market rent. So say that the house should be renting for $3,000 a month. They would write the lease at $2,000 a month, and they would write a long lease so that they were able to stay in the property for a longer period of time at reduced market rent. And I remember going to court many, many times for the bank, testifying on the bank's behalf that this was probably a fraudulent lease because of the term of the lease and the amount of the lease. But ideally, you don't want to get into that. You want to have everything written, everything prepared and sent to your heirs so that they know if and when the time comes what to do and what the situation is. An ounce of prevention is worth a pound of cure, and in this case, it certainly would have made it a lot easier for the daughter, particularly because she lives out of state. I really try on this channel to give all kinds of information and ideas based on the feedback that I'm getting from clients and the different scenarios that I come across day after day. This one was a new one for me, so I had to kind of get creative and reach out to other members of the team and find out what they thought the best scenario would be. I'll do an update on this to let you know, was there a month-to-month? Was there a lease? Did they have deposits? And kind of what happened later. If you have any questions, comments, remarks, or ideas for future episodes, please let me know. I do read all of the comments and always want to provide you with the best, most up-to-date, informative content.